have registered that. Still yet, they still neglect all of those fact-finding process that it was still the office that established it. In this testimony that we have here, they have acted only on 3 people's testimony to give this recommendation. The RI0USLY, Primary and Wunmi. Even Adura is not there. Spending is not there. Hospital is not there. The only line they included in the other thing is that days after the event, he bled profusely. Days. In which care did he bleed profusely? In which person's care? Where did he bleed profusely in the street? Did he bleed profusely in the hospital? Is it in Prime Boy's house that he bled profusely? Is it in Nurse's house that he bled profusely? Before the nurse came in, he has been bleeding profusely for days. And somebody is telling me that the inquest has not registered anything. Let them come and do the recommendation, make we come here. Let them come and do the inquest recommendation. How people will not continue to go back to go and start getting lawyers. I want to see it. So by Solide, this is
yeah, that's on that. Yeah. So
I don't know if I can quickly show the application of the Alobas family. The writ of summon. It was filed March 2020. It's 115 pages, but it's still. This is in order rule brought pursuant of order rule 44 rules 1, 2, and 3 of the High Court of. This is not Sam Larry. This is not Naramali. This is the Aloba Mohbad father challenging Honorable Attorney General of Lagos State, Director of Public Prosecution of Lagos State, respondents. They are challenging the government, not Sam Larry, not Naramali. And they are doing it based on Section 36 of the 1999 Constitution of Federal Republic of Nigeria, that everybody must have a fair hearing. Baba Mohbad deserves a fair hearing in the case of the corona. Whether corona is a tribunal or something, it is still under the jurisdiction of the Constitution of the Lagos State. So they need to have a fair hearing. So for people saying that somebody this is not this is it. See it? DPP legal advice. Lack of fair hearing. Section 36 of the 1999 Constitution of Federal Republic of Nigeria, preempting. That is, the DPP is preempting the outcome of the corona inquest, which is wrong.
By a billion.
Manipulation is to direct.
It's manipulation.
By a billion.
Direct the corona inquest.
Yes, they are preempting on behalf of the corona inquest, so that they can direct corona inquest to that angle. You are right.
Sanolaide, please, can you help us get in touch with Section 211, subsection 3 of the 1999 Nigerian Constitution? Thank you. Mr. Bayobilon, go ahead.
Yeah, you understand what I'm saying? They are trying to redirect.
You want me to say it, or I should just get in and...
Exactly. That's what they're trying to
get it down. Let Bayo finish, then you take us on that section.
See, they are preempting. And you know that the preempting of a case is even a crime on its own.
It's a crime. It's a crime.
It's a crime.
It's a crime.
This is abuse of power right here. Preempting of the corona inquest, that proceeding that has not been concluded.
Power on.
It is a
and I want to say that is the reason why they have hurriedly concluded the case of the DPP of their Lobas.
Fast, yes.
DPP.
And that's why
it's not so fast.
As the base for we to appeal this kangaroo judgment.
Yes.
We have a case to appeal based on the section that you just said now, because section 211 subsection 3 of the 1999 Constitution of the Federal Republic of Nigeria, as amended, provides as follows. And we are going to critically talk about that when we are talking about the ruling that was done 2 days ago. And in exercising his powers under this section, the Attorney General shall have regard to the public interest, 1. 2,
Guys, let's
interest of justice.
Barrister Lade,
And last, no, let me read that finish.
hold on. Mofekon, please, let's be noting the key words the Constitution is saying. Mr. Tarzan, I know you're here because you critically listen. Please let us listen carefully to what this Section 3 is saying. Thank you. Barrister Lade, go on.
Yeah. So the power of the Attorney General of a state is in section 211. But we are now referring to the subsection 3 of that constitution, of Nigeria Constitution 1999, as amended. In exercising his powers under this section, the Attorney General shall have regard, 1, to the public interest, 2, the interest of justice, and 3, the need to prevent abuse of legal process.
Of power. Legal process and power.
Of legal process. These are the 3 things. We are going to talk about this much later on when we are talking about the ruling to why we are going to appeal this. And again, we need to look at how we are coming on just one back. We are representing the public. Every one of us. Even if you are anti-justice, you're pro-justice or anything. The interest of the Attorney General must be clear. The public interest will be put into place. The interest of justice, what is justice to us? It will be put into place, not what is justice to Lagos State government. Yes, they are the prosecutor, but what is justice? Because we said justice for Mohbad. And lastly, to prevent abuse of legal process, he has already abused that as far as we are concerned, because he has jumped the gun. They set up this. Lagos State government set up Corona, and they have jumped the gun, and they are abusing the legal process. And that's why we are going to challenge this. We are going to challenge the ruling. Just to give the section the basis of why we are going to appeal this. 1, again, we need to state it clearly here. The power of Attorney General of Lagos State or of a state in Nigeria, the 6 states in Nigeria, is to exercise his powers under this section. The Attorney General shall have regard to the public interest, the interest of justice, and the need to prevent abuse of legal processes. Barbulance can continue. Thank you.
Okay, thank you. So, I'm going back to the grounds for the application, preempting the coroner's inquest proceedings by the DPP in its legal advice, which is yet to be concluded, sitting as can be put on the abuse of legal process, because they are preempting as an individual, as a body, as an entity, is a crime on its own. You cannot be your own judge in your own case. You cannot say that because we are the Attorney General of the state, we can say that this is what we want. The Constitution does not allow you to do that. As the Constitution gives the Attorney General power, it also gives public interest and the rule of law of the state power too. Also, vital suspects mentioned and implicated in the coroner's proceeding are being allegedly freed by the DPP's legal advice. They were the one that mentioned and implicated them. You mentioned these people, you implicated them in your own findings. So why are you allowing them to go? And as at March 2025, March 12, they have not said their own findings at the coroner. As at March, when this application was filed, Prime Boy have spoken, driver has not spoken, the doctor of the hospital have not spoken, the coroner have not spoken, the pathologist have not spoken, even the nurse have not spoken at the time. Even this nurse himself that they claim to be the prime suspect has not spoken at the time. So this we're just bringing all of this to your attention to let you see that this case is not against an individual, but it's a case against the state versus Aloba. So for the wrong narrative and the wrong exercise and exercise of mouth, please, this is not a case against a certain individual versus individual. It's not a personal attack. It is a case against Aloba's family and the True Justice Seekers versus the Lagos State Government, Attorney General and the DPP. Thank you. Basalade, are you ready to go to the
thank you so much,
CTC for the
thank you so much. Yeah, thank you so much for running us through the legal advice from Lagos State Government and also our own originating motion filing against. I'm trying to look for the, because it's a 7-page legal ruling. It was sent that been sent from the legal team of Mohbad sent to Baba, so we can look into it and check what is in there. So we just got it and we want to do justice to it. But I think we've gone through the ruling. We just need to check. Sorry, I'm sorry. I need to quickly do me. So give me 1 second. 1 second, please. Thank you.
Abi, you don't. Wait till you drink. That's all. Wait till you drink. I know you know you drink.
Let me quickly. Emi need projector. You get projector, so maybe you can project it.
Oh, do you want me to project it? If I project it, can you read it?
No, they can see it from there, so I can be reading from the spot again. Let me just read the listing. So again, so that for people that are misleading the innocent people, or that are willfully blind, or they want to be blind for life. Again, we need to go back to the base where we are here. We are trying to analyze or talk about the Joseph Aloba versus the DPP and Attorney General of Lagos State. And Justice Olatokun was the one that gave the verdict at the High Court. And in the Ikeja Judicial Division, on the 2nd day of July, Joseph Aloba versus the Honorable Attorney General of Lagos State and Director of Public Prosecution. And he said the ruling is in respect of an originating motion on notice dated 12th March 2025, but filed on 13th of March 2025. The applicant pursuant to Order 44 Rules 1 and 3, Subsection 2 of the High Court of Lagos State, Rules 2019, filed a statement dated 12th March 2025, seeking the following relief. 1. An order of the judicial review to writ of certiorari application in terms and on grounds set out in the statement filed herein. An order of certiorari to remove for the purpose of being quashed the legal advice, decisions, recommendation of the respondent.
By Solade, please hold on. An order to remove the purpose of being squashed, the legal advice.
Of course.
The legal advice, not an individual. Baba Mohbad does not care about Sam Larry or Naimal. It is that advice, that action that the DPP took that he wants out of the way. He does not want them to have that decision without having a proper hearing. So go ahead, sir.
Yeah. Of the respondent to read Director of Public Prosecution, Lagos State, with reference number, in respect of the murder case of late Ileoluwa Aloba, aka Mohbad. The grounds upon which the reliefs are sought are: the respondents have hastily acted in excess of jurisdiction, perverted course of justice, and violated the principle of rule of law, justice, equity, and fair hearing.
Section 36
of the Constitution of Nigeria, 1999 as amended.
Yeah, 1999 as amended.
B.
Obviously.
The respondent's action is made without or in excess of jurisdiction, and the court is urged to restrain the abuse or misuse of power or to correct errors of law, wrong exercise of discretion by the respondent. C. The action of the respondent is premature, hasty, and preemptive of the outcome of the coroner's
proceeding. Look at the clap now. Look at the clap now.
Action of the respondent being fully aware of the coroner's inquest and having fully participated in the proceedings and without informing the coroner proceed to issue legal advice discharging the prime suspect is to undermine the integrity of the coroner. E. The action of the respondent constitute an affidavit. Constitute an affront to the exclusive jurisdiction of the coroner's power to conduct inquest into suspicious and unnatural death is expected to run its course without external interference. F. The action of the respondent accounts to destruction of the statutory function to conduct inquest into unnatural and suspicious death, which may further assist the police in their investigation. This is our Nkotagbe Loba. Let me speak about. Let me put some to about the Nkotagbe Loba High Court Lele without mentioning anybody. We are only challenging the advice, the recommendation of the DPP. We are less concerned about Sam Larry. We are less concerned about Babatunde Opere. We are less concerned about Naamali. So I heard when a clown was saying yesterday, who brought another clown on their show to say it's because Baba did not join hand with that clown. That is why we did not get the favorable judgment. We are not going to address those people anyway. We don't care about them. All we care is fair hearing, which we have done the right thing. So I think we need to check out the resolution of the judge. So the judge is saying the resolution of the outcome of the legal challenging the outcome, challenging the legal advice. He said the court has carefully considered the fact and finds that the parties have raised and argued similar issues. The whole issue for determination therefore is whether the applicant has established grounds for the grant of an order of certiorari to quash the legal advice issued by the respondent. The court is invited by the applicant to determine whether the legal advice issued by the second respondent while the coroner's inquest into the death of late Ileolu Oladimeji Aloba, aka Mohbad, was ongoing, which resulted in a discharge of some of the suspects, or to be quashed by an order of certiorari. The learned silk, that is Wahab Shitu, for the applicant, argued that though the respondent has the power to issue legal advice, the legal advice issued in respect of a matter pending before the coroner and in which the respondent participated in the proceedings was issued without jurisdiction, as it amounts to the usurpation of judicial function of the coroner court. It was submitted that the respondent actions is in haste, premature, and overreaching the outcome of the inquest, and the legal advice ought to be quashed. It was submitted that the police investigation cannot reasonably be said to be conclusive, as the outcome of the inquest may reveal and demand further investigation from the police. For the respondent, it was argued that the essence of a judicial review and the duty of the Honorable Court is to determine the legality and not the correctness of the action of the respondent. Learned counsel for the respondent cited and quoted extensively the decision of the Supreme Court in the case of the governor of Oyo State, versus Oloyan, 1995, decided the case in 1995 between Oba, whatever. It is stressed that judicial review by CAS3 is a mechanism to supervise decision of inferior courts, tribunals, and administrative bodies. It is not an appeal, but a limited jurisdiction concerned with legality and not the correctness of the decision reached. This principle was emphasized in the case of ACB PLC versus Nwagwe and others, 2011, cited by the respondent. Learned Sikh in adumbration submitted that though the coroner inquest is a fact-finding tribunal, his recommendation will guide the Attorney General in determining whether or not to prosecute. It was submitted that the Attorney General, in exercising the power in Section 211, subsection 1 of the Constitution, is guided by Section 211 of Section 3. It was submitted that the action of the Attorney General in this case is not in the public interest, not in the interest of justice, and it's a gross abuse of legal process. We've mentioned this earlier on about that. So the principal contention rests on whether the first respondent acted ultra-vires or unlawfully, is exercising his statutory of constitutional discretion while the coroner's inquest was still ongoing. The powers of the Attorney General under Section 211, subsection 1 of the Constitution are settled and unassailable. Section 211 of to institute and undertake criminal proceedings. 2, to take over and continue with proceedings. 3, to discontinue same at any stage before judgment. This power may be exercised personally or through officers of his department. See Section 211 of Section 2 of the Constitution, blah, blah, blah. So the contention of the respondent in paragraph 4 of the counter affidavit that upon conclusion of the investigation by the police, the investigators forwarded the duplicate case file to the office of the second respondent for a review, issuance of legal advice is in accordance with the provision of Section 74 of the Administration of Criminal Justice Law of Lagos State, 2015. The legal advice issued by the Office of the Attorney General with respect to offences triable on information shall be conclusive. The argument of the Learned Sikh is largely premised on ongoing inquest into the death of Mohbad. However, it is noteworthy that the coroner's proceedings under the Coroner System Law of Lagos State, 2007, are inquisitorial and investigatory in nature. The coroner is tasked with determining who was, how, when and where the death occurred. The coroner does not determine criminal liability. Therefore, there is no statutory or judicial basis to conclude that the issuance of legal advice by the respondent while coroner's inquest is pending amounts to an illegality or intrusion of coroner's powers. So, in the concluding part of the judgment by the Bible on the last page 7, please. So we can end this once and for all, and we can just post it or share with others so they can read. It must be noted that the coroner's proceedings may generate facts or perceptions that do not meet the threshold of legal proof required to prosecute. The legal advice being challenged by the applicant reflect a Victoria evaluation that no sufficient link was found between the suspect and the cause of death of the deceased. This court cannot substitute its view for that of the second respondent. The role of this court is not to supervise this prosecutorial decision of the respondents. The powers granted to the respondent by the Constitution and the ACJL are broad, final, and immune from judicial intervention, except where illegality, irrationality, or procedural impropriety is clearly established, which, as far as I'm concerned, I disagree totally here, and which is why we need to go and appeal this, so we can discuss that later. None of these have been demonstrated in these applications, particularly in the light of the fact